first of all, thank you so much for having me here. Now, with Sai already having set the tone for the debate, my primary disagreement with him was as how the title to this debate is, as right of deity versus the right of worship. Now, my concern is that, of course, before his clarification ensued, but as it comes out from the judgment itself, that it appears that deity is being given an identity under Part 3 itself as an individual. And then they are saying that, yes, the deity's rights should also be considered vis-a-vis the rights of the citizens. To that extent, that is positioning the law at a very high level and as a very high target to meet. But now having clarified that it's not right of deity as it appears in the judgment itself, but as more of a representational right or a group right of people belonging to a certain religion, having a certain faith and following a Lord Allah. So now the debate as it is positioned is actually the group right of the followers versus right of the individual to ascertain her right of worship. Now the example that Sai gave was right to practice before the Supreme Court. And he says my individual right should prevail over the laws or the regulations set up for a particular place. My objection with that is that right to profession comes under Article 19 and right to religion comes under Article 25. Now, this is a choice that I am not making. This is a choice that Constitution makes for us. Because Article 25, which talks about right to religion, says it is subject to other rights in Part 3. So when the right flows out of Article 14, 19 or 21, it is put as a higher pedestal than my right to profess my own religion. That is where the fundamentals lie. So it is not the choice that is left to me as an individual. It is a choice that Constitution has made for me already. So any right that flows out of 14, 19 and 21, for example, sexual autonomy, Navtej Singh Johar 377 just came out, all of those rights are of superior nature than right to religion. So religion as an aspect of life itself is given a secondary nature in the Constitution. Then the individualism or the rights flowing out of that individualism. So the concepts like individualism, liberty, limited role of the government, limited role of institutions, or divisions in the society, like caste, religion, giving you a group identity, are placed in the secondary box. Now, what is the basis behind such classification? Because it is my case that as long as this prevails, as long as Article 25 is subject to 14, 19 and 21, there is no choice but to put religion as a secondary nature. Religion as an aspect of life is not as important as any other aspect of life may be, which flows from 14, 19 and 20. That is the choice that Constitution makers have already made for us. And as long as the Constitution stands as it is, there's nothing much that we can do about it. Even personally, if I want to make a choice, it will be subject to 14, 19, 21 above Article 20. Now, what is the basis for such a choice being made by the Constitution for us? The basis is the concept of secularism. The concept which was evolved in the Western society. In the charged atmosphere, it prevailed since the 17th century. which has been, after some tweaking, adopted into the Indian context. So when Sai says that you have to understand what the religion is about, what the Hindu religion is all about, I actually agree with him to that extent. Because then the debate would be that do the concepts of secularism as they prevail, as they being ratified by Supreme Court or other constitutional courts of this country, as furthered by scholars, political leaders, as reflected in legislations, actually adapts to the Indian society or not. To that extent, I like to rely upon some scholars on secularism who actually done some research as to how it came to be and what it reflected before it was adapted through across democracies. So Beckford is one of those scholars who points out that notions of secularism originated in philosophically disputatious and ideologically charged settings. There was never a moment in formative period of social and human sciences when questions about trajectory of religious beliefs, practice, and influences did not carry explicitly or implicitly a strong ideological charge. And these were integral to the complex controversies about the growing authority of science, scientific institutions, and organizations representing the professions. The historical reasons behind this are that the 17th century, continental Europe experienced bitter and prolonged wars. As a result, the political foundations of modern Europe were built on the consensus that religion should not be allowed to become a divisive factor in public life. Furthermore, modernization in Europe occurred over a long period of time, during which the institutional religion was often seen as an enemy of modernization process. The anti-modernist stance of the Catholic Church influenced many writers of the 17th and 18th century and 19th century, from whose ideas Western understanding of the modern world has evolved. Most of the 19th century founders of modern sociology added to this conviction that religion was already declining and would decline further as modernity advanced. Comte, Marx, Durkheim, and Weber all held such views. And most of you wouldn't agree that these are the philosophers, sociologists who formed the basis of the modern concept of secularism, which, after some minor tweaking, has been copy-pasted into the Indian context. So as it stands, the choice is already made for us, where religion is only meant to govern personal affairs, spiritual affairs, my relationship with the Creator. But the moment we enter into a public space, even when it is controlled by religion, or it's a religious space, religion takes a back. Yes, that's the irony. I may not logically agree with it, but this is what it is as it stands today. And it is from here that the courts get the right to decide as judges, so what is important in religion and what is not. So people who are the helm of affairs of the religion, they don't decide that, the judges decide it. Doesn't sound logical, but that's what the law is as it stands today. And that's exactly what has happened in the Sabrimala matter also. So the group rights as a religion have taken a backfoot. And individual rights, rights reflecting our liberty as individuals, takes a front. And that is why Article 25 starts with the fact that it is subject to other rights flowing out of fund. And that is why the judgment and the law it is as it stands today. Therefore, as long as it is, until unless it is amended, That is the law settled by the courts using the tools which were evolved out of this very concept of secularism and religion, and the choices that are made for us by the Constitution itself. As far as the concept of religious denomination is concerned, the finding is clear that group rights as they are understood only flow out of a denomination. And since the respondents have failed to prove that followers of Lord Ayappa form a separate denomination, there is no group rights as it exists in this debate. Therefore, the finding comes that it is the individual right that will prevail. That is the right of women to enter, irrespective of the stand of the group or the religious people, that there is a public space regulated by religious beliefs which may be respected. So to that extent, I disagree with Sai. It is my case that the Constitution as it stands today reinforces the belief that individual libertarian rights flowing out of 14, 19, 21 prevail over the rights coming out of Article 24. And the tools that were used by the court, whatever they may seem to you, are what prevails in the law today. And therefore, the only conclusion that could have been was what is reflected in the judgment. This is my case. Thank you so much.